You may be seated.
We are on the record. This is State of Utah versus Shane Peterson, 241901993. Time set for sentencing.
All right, Mr. Peterson is present. I'll have counsel make their appearances, starting with the state.
Letitia Toombs, Weaver County Attorney's Office, on behalf of the state of Utah.
Kevin McGahan for the state, Your Honor.
Brandon Merrill on behalf of the victim's representative.
Jason Widdison for the defendant.
Logan Bichelle on behalf of the defendant, Shane Peterson.
All right, thank you. Thank you for being a little bit patient. Well, I guess we're still starting on time, but truthfully, we didn't realize we might need to move courtrooms. So thank you to Judge Hall for accommodating that, and also security for over quickly. We are set for sentencing here today, and as we get started, let me sort of give you some idea of how we're going to proceed. First of all, I think that this is a situation where we may have, I think, a letter read. I don't anticipate that there would be other people who speak either on either side other than the attorneys then, and Mr. Peterson, other than that letter being read. And let me indicate what I have gone over and what has been provided to me prior to sentencing so that the record is clear. And then I'll let Mr. Bichelle and Mr. Widdison speak, then the state present, and then finally Mr. Peterson. First of all, I did receive a copy of the pre-sentence investigation report that was prepared by Adult Probation and Parole. Did you receive a copy of that? And Mr. Bichelle, who's going to, Mr. Widdison?
Your Honor.
Mr. Widdison, did you receive a copy of that?
I did, Your Honor, and we reviewed that.
All right.
Mr. Peterson, no legal reason why we can't proceed.
All right. Then if you want to speak to any corrections or additions, I'll certainly let you do that as part of your sentencing presentation. In addition to the PSI, I received statements from Maisha Palmer, Scott Peterson, Mandy Martinez, a letter or sentencing memo prepared by the state, which included a letter written by Gavin Peterson as part of one of his school projects, a report written by Dr. Antoinette Lasky from the University of Utah, professor of pediatrics, diagram of the Peterson home. Then I also received a letter from Jennifer Morse, Melanie Peterson, and then today a letter from Dolan Ravoda, and I'm sorry if I'm saying that wrong, and Krista Mendez came in. And then finally, I do have this letter that came from Melanie Peterson, one of the listed victims and the older sister of Gavin, and I think that's going to be read out loud. So I wanted it just to be clear, both on the record and to the parties, that that's what I had reviewed. I also know that there were a significant number of things submitted by Mr. Widdison and Mr. Bichelle as it related to graduation certificates or course certificates that Mr. Peterson had completed while he was over at the Weaver County Jail and while he's been in custody. Is there anything I missed from the state?
Exhibit number 4 was provided as well.
And then there were videos and photographs that were provided to the court as well. Anything from the defense?
Nothing.
All right. Then Mr. Widdison?
Thank you, Your Honor. My comments are brief, just that pursuant to the plea agreement in this case, we're asking the court to impose the prison commitments consecutively, and Mr. Peterson would like to address the court and will submit.
All right, thank you. Ms. Toombs.
Your Honor, Ms. Pitt will be reading the letter from named victim Maimani.
Dear Judge Snyder, my name is Maylani Peterson. I am writing in regards to Shane Jesse Peterson's sentencing in the death of Gavin Peterson, my brother. My life has been completely upside down and forever changed since July 9th, 2024. My little brother meant so much to me, so learning about what happened to him really took a toll on me emotionally. I wake up every single day with anger and sadness that Gavin can't be at home with his real family. The damage this horrific crime has inflicted on my closest family members and myself is 100% irreparable. Gavin had one of those souls that was one of a kind, and he deserved the life that was taken away from him and so much more. It makes me feel physically sick to my stomach when I think about some of the things Nicole Scott did to him, and I will never forgive her for any of it or for anything else that she did. My family and I will be grieving Gavin for the rest of our lives when we should not have to. Both Nicole and Shane are completely incapable of being decent parents and should never have another child in their care, let alone the ability to live with a regular life outside of the prison walls. Shane fully allowed Nicole to physically, emotionally, and mentally abuse his children, and absolutely no point did he show any sign of discomfort with what was happening or any desire to stop it. My entire life, all I wanted was a father who loved and protected me and my siblings the way I thought Shane would. Instead, we were left with an emotionally unavailable man who cared more about protecting his own image than he did being a dad. I don't ever want to be recognized or known as his daughter. I find it disgusting and insulting beyond any amount of words. I can't even remember the last time he hugged me or my brothers without using one arm or staring down at a phone screen the entire time. It hurts even more to see children have a good relationship with their dads. As much as I would never wish for any child to go through any kind of abuse. I still wonder why Shane could be anything like those dads, why he couldn't be anything like those dads. My father is not a father. He is a full, empty shell of a man who only cares about benefiting himself. He knew everything horrible that was going on and didn't even have the heart to think about how humiliated and alone Gavin must have felt. He didn't care. He made sure himself and Nicole were always full and had a warm place to sleep, while they left Gavin with nothing. The only form of closure for me would be for both of them to die the same way they robbed him of more than just his life. They took every memory he was supposed to make and every important milestone he was supposed to read, every "I love you" from our mom. Now I will never get to grow up with him again and watch him enjoy the rest of his childhood. Please don't give these inhumane people a second chance at living a normal life. That is the first thing Gavin deserved. Thank you.
Thank you, Ms. Pitt. Ms. Toombs.
Your Honor, I will keep my remarks very brief. I think that the state outlined our position in the sentencing memorandum. We have identified aggravating factors which certainly lead the court to be able to make the findings necessary to impose all of these sentences consecutively. As just a brief recap, we have 3 named victims. Of course, Gavin has been the forefront and should be the forefront. The fact of this case is probably the most distressing fact of this case is the absolute dehumanization of Gavin. And I want to say his name again, Gavin, because they took that name from him. Shane took that name from him. He was never called by his name. He was called by other pejoratives. Gavin was dehumanized, isolated, starved, beaten, and ultimately died. This defendant, as his biological father, did nothing to stop what Shane did, or what Nicole did, and he also actively participated in the abuse. When the school called out, he said, "Don't feed." When DCFS came to the door, he said, "You're not allowed in my house." Shane took the benefit of a bargain, and we would ask that the court uphold that bargain, which was to give him the maximum sentence possible. Thank you.
Thank you, Ms. Toombs. Mr. Merrill.
Yes, Your Honor, thank you. After this ultimate incident of Gavin's death occurred, Ms. Peterson and I, we had to go to the courts to get possession of Gavin's body to bury him in according to the wishes of his mother. It was only after we got that court order that then we were reached out to potentially try to cremate his body and split the ashes, which was obviously abhorrent to what Gavin had to go through because he deserved to be laid to rest away from this terrible person that allowed this to happen to him. The way that this man has used his money and his power to manipulate the court system to get full custody of Gavin, to allow this to happen to Gavin, to his children, and to the mother of his children is absolutely abhorrent. For the survivors of homicide victims, justice has nothing to do with handcuffs. And they will never get full justice. And Gavin will never get full justice. And the only way to even get an iota of that is to make sure that this man never sees anything other than those walls of the prison. Thank you.
Thank you, Mr. Merrill. Mr. Peterson, anything you want to say to me? I'll ask you to stand. Your counsel can stand with you.
Yes, Your Honor. To my kids, especially my daughter, I'd like to express how deeply sorry I am for my role in the abuse and the trauma that they all went through in my home. I've had several opportunities to interfere and protect you, but I chose not to do so. I am truly sorry, and I hope that one day you can forgive me. To my ex-wife, I am so sorry for how Gavin was treated in my home. I allowed this abuse to happen, and I did nothing to stop it. This abuse no doubtly was the cause of his demise, but also robbed you of the opportunity to know and love our son. I am so sorry from the bottom of my heart, and I hope that someday you can forgive me.
All right, thank you. I do want to make a couple of comments, a few comments, and I can appreciate that everyone's sort of relying on the documents that were sent to me. They're also relying on the agreement that was made for consecutive sentencing. And I know that there's been enough public interest in this case that I wanted to explain a couple of things as we go forward with the sentencing and why this has seemed a little bit abbreviated, I guess. And normally, I mean, there are not a lot of murder cases or homicide cases, I guess is the better word, as it comes to this charge. There's not a lot of homicide cases that result in a plea. There are some, but it's kind of unusual. And often, from the beginning of a case, especially those of us involved in the system, try not to be, well, for one thing, someone in Mr. Peterson's situation has the presumption of innocence until a jury decides that he is guilty or until he says the word that he is guilty. That's an obligation for the court to uphold and to protect until that change is made. As part of that, you might be surprised that as a court, we don't know a lot of information about a case until really we either go through an evidentiary hearing, maybe a preliminary hearing, which we didn't have in this case because it was waived, and that's understandable. But in addition to that, we didn't have a trial because Mr. Peterson and the state came to an agreement, and so we didn't hear witnesses testify or all of those things. And so really, up until the time he pled, in an abundance of caution and trying to presume that and to afford you that constitutional right of presumption of innocence, I haven't known a lot about the case. And that was deliberate on my part. When it comes to some of these cases, they are harder than others. Child death is always a case that's going to be difficult. But I don't want in any way, shape, or form anyone to think that we are brushing either the prosecution, the defense, Mr. Merrill's representation of the victim, that we are rushing or brushing anything under the carpet as it relates to Gavin's death. And some of that has been, some of those are public documents, but truthfully, a lot of them are not public documents. I don't even see necessarily all of the documents. I don't read the police reports. I read summaries of those. There was videos that were provided to me and photographs that were provided to me, but they're not ones that are going to be made public under any circumstance because I think it's everyone's position, and especially my position, that anyone getting a hold of those certainly would be detrimental to Gavin's legacy. And that Gavin's legacy should be the picture that I have seen, and until the other pictures were sent over, the only picture I have seen, the school picture of him with his big smile, and I think that the media has used that as a family photo, but I think that that is the only legacy that should be able to be found by anyone who is searching for him. But I did want to emphasize a couple of things that came out in the reports that I don't think were part of the everything that has been dealt with. And I want to, first of all, commend the state and the defense, frankly, for taking this and treating this case with all of the sincere responsibility that both sides have. And I certainly I am appreciative of how it resolved, but that doesn't change how we handle the sentencing and what we do. There was a report that was written by Dr. Lasky, who's with the University of Utah, and she had some very, very valuable insights that I didn't see in any other document. And part of these, Mr. Peterson, I don't know if you've seen this. I would assume that you have access to it, but I'm also very aware that sometimes in your situation, people will bury their head in the sand and not acknowledge the true devastation or the havoc or the harm that resulted from their behavior. And I want to read part of this so it's clear in the record. First of all, she does outline that Gavin passed away when he was at the hospital, that McKay-D surgeons made heroic attempts to try and save him, and he died in the operating room where they were doing that. That Gavin's autopsy revealed he had sepsis, which was a bacterial infection in his blood, and it's led directly to his death, with additional relevant findings of dehydration, pneumonia, malnutrition, and because I'm not a medical provider, I'm going to use the regular word of severe bed sores. The investigation revealed significant concerning indicators of what he was enduring at home. He was always hungry and scavenging food. Due to repeated attempts to have his safety evaluated by DCFS, his caregivers ultimately removed him from school entirely, further worsening his isolation. He endured not being allowed to wear clothes other than diapers, being force-fed and possibly volitionally, meaning he then started to eat it on his own, feces, being subject to extreme discipline, confinement, and forced tasks such as cleaning in ways that would have been considered outside the norm. In the days leading up to his preventable death, his father reported he was vomiting and had at least one seizure. No medical care was sought. It's likely that the symptoms described were the early signs of the bacterial infection that would soon kill him. Notably, he has multiple possible explanations for the sepsis: ingestion of the feces, the severe bed sores, malnutrition leading to pancytopenia, which I had to look up too, but it's a blood disorder, and subsequent reduction in immune response. The information available in this case is clearly consistent with severe psychological abuse, physical abuse, malnutrition secondary to food restriction, and child torture. Gavin likely endured unimaginable suffering in the weeks, if not months, leading to his death. The history provided is consistent with child torture. Child torture is a medical diagnosis that includes components of severe physical abuse, restraint, unusual disciplinary practices, Starvation and severe psychological abuse, including isolation, spurning, verbal abuse, and terrorizing. Child torture often ends in the death of a victim, but prior to the death, the child is so psychologically traumatized, it is not uncommon that they will begin to manifest psychiatric symptoms. A child of Gavin's age is still dependent on caregivers to provide food, shelter, clothing, safety, nurturing, and medical care. However, they are at an age where they can attempt to save themselves from things like starvation by scavenging food or eating non-food items. The hunger drive-in starvation has been well documented in medical literature. Gavin was most likely aware of the fact that there was food and that the rest of the family was eating. He also probably smelled the food they ate. It is likely this caused substantial anguish and distress. A common late-stage manifestation of starvation is the ability to overcome revulsion and eat non-food in an attempt to sustain themselves. Considering the psychological abuse Gavin endured, being isolated from children at school, outside contact with anyone, restriction to his room, constant monitoring with cameras, not being allowed to wear clothes, being forced to wear diapers, being deprived of love and medical care, all would have been profoundly impactful on his psyche. By report of the school contacts, this was an essentially normal child who was driven to a point of psychological breaking. He would have been cognizant of what was happening, understood that it was wrong, and that the adults in his life who he should have been able to rely on for all things were, in fact, his tormentors. It is without question that Gavin experienced physical pain prior to his ultimate death. His body was riddled with evidence that he was beaten more than once. The lack of body fat and diminishing muscle likely made the pain worse. And I can tell you this is part of why the state has kept their presentation short. To summarize, the physical injuries identified in Gavin, his state of malnutrition, and the subsequent history obtained support that he endured child torture in the days and weeks, if not months, leading to his death. He would have been cognizant of what was happening, how he felt, and who he should have been able to turn to for care and support. He would have been hungry to the point of being willing to risk known physical consequences in order to obtain any sustenance, to keep him alive and to overcome the innate disgust of ingesting feces. He would have felt fear and sadness and pain. Furthermore, his siblings would have sustained psychological trauma as a result of being in the same environment. As a judge, we are to sentence based on the facts. But nobody sits here devoid of emotion, empathy, human experience, or just common sense. You don't have to be a parent. You don't have to be a criminal. You don't have to be any of those things to think, oh, maybe this should be wrong. The reason I emphasize that, and it does make me emotional, because I think of, first of all, you were Gavin's dad. I don't think you deserve that title anymore, but there's nothing that can be done to change it. You certainly were not his father, and you certainly were not his protector. I don't believe for a minute that you weren't part and parcel of a significant portion of the abuse that he endured. I also find it telling that I'm more emotional about this than you are. And I think that there is reason for that. I don't think there are enough adjectives and adverbs to adequately describe how awful this situation is. And the fact that I'm teary about it is the first time in 25 years that I can think of that I have ever gotten teary in court, other than something that I was here for of a personal nature. And part of that is because this case compares to none. I've done Ms. Toombs and Mr. McGahe's job. I've done Mr. Widdowson and Mr. Bichel's job. I've prosecuted and defended child homicide cases, and I know what goes into that. As I said before, I respect the job that all of them have done here. But this has got to be one of the hardest situations any of them have dealt with. And it's absolutely unacceptable that your behavior was such that it ever took place more than once, that you allowed, condoned, encouraged, facilitated, and probably participated in any one of those instances, let alone instances that went on daily, for weeks, and for months, and potentially even years. It doesn't help you that a lot of the text messages and the cameras were hidden, and there was an attempt to cover up, because anything that you might tell me to explain why falls on deaf ears. If there was evidence of that, you wouldn't have deleted all of the things that got deleted. So the presumption really is that those were things that were going to be worse than what we do actually know. We don't know how long it went on. We don't know how many times you actively participated or how many times you were just aware of it. But the truth of the matter is, and I agree with what Ms. Toombs said, you dehumanized that little guy. And it resulted in his death. And the responsibility for that lies at your feet. I don't think that there is anything that, looking back in your past, and I got a couple of letters in support for you that wanted me to understand what kind of a character you really are, what kind of character you really have. I want you to understand that those things that you might have done that were good in the world have all been completely wiped away and eliminated by what happened here. I can appreciate you've made use of your time over at the jail, but to think that you might think that I care one bit about some of the courses that you've taken over at the jail, and that in any way that may balance what has to happen here, you are wrong. Those are pieces of paper that are shallow and pale in comparison to the life that you contributed to taking. And I hope that you understand that. I agree that you should be given the maximum sentence. I am going to run it consecutive. I also am going to encourage the board to keep you until you die. That is up to them. But there is no, if you're able to do this to your own child and allow it to be done to your own child, I cannot fathom that you can be rehabilitated. And it doesn't, again, make a difference that you don't have a criminal history. The consequences are that you did this to your daughter, you did similar things to your daughter, or allowed similar things to happen to your daughter. But even in Gavin's circumstances, I don't think there's any price that you can pay, any penance that you can offer up that the board will recognize as penance significant enough to make it safe to let you out. There's a lot of cases where I want somebody to have a glimmer of hope, that maybe if they go down to the prison and try, that maybe they'll get paroled. To be brutally honest, Mr. Peterson, I don't care if you have that glimmer of hope. I'm not going to send that glimmer your direction. The Board of Pardons might. But I do think you're entitled to the maximum sentence of this case. Mr. Peterson, if you and counsel will stand. In connection with your conviction for aggravated child abuse I'm going to start with the child abuse homicide. In connection with your conviction for child abuse homicide, recklessly causing the death of Gavin, that's a first-degree felony, and the court will sentence you to 5 years, and that will 5 years as a minimum and up to life as a maximum. In aggravated child abuse, intentionally or knowingly causing child abuse is a second-degree felony. That is in relation to Gavin as well. The court will sentence you to a sentence of 1 to 15 years in the Utah State Prison. In aggravated child abuse, intentionally or knowingly is a second-degree felony. As it relates to Maylani, that sentence will be 1 to 15 in the Utah State Prison. As to aggravated child abuse, there's a third count there, intentionally or knowingly as a second-degree felony. The court will also sentence you in accordance with the statutory scheme of 1 to 15 years in the Utah State Prison. In the final charge of endangerment of a child, a third-degree felony, that is the exposure for the third child and the third named victim, the court will enter a sentence of up to 5 years in the Utah State Prison. I will run those consecutive with each other, consecutive with any other sentence that you may be serving. I'm also going to order, are you stipulating to the restitution?
Your Honor, on that point, we're asking to set a review of restitution in 60 days. The state has asked for, or the victim lawyer has asked for some financial information that we need to provide.
But can we order the amount for the funeral?
Yes, Your Honor.
All right, so I will order $1,325.34 payable to UVOC. I will leave the remaining restitution potentially open, and that needs to be requested in writing within 60 days, and I'll set a hearing after I see a request in writing, and that will be an opportunity to respond. But the restitution to UVOC will go down to the to the Office of Debt Collections immediately, and that can begin to be collected if there's a way to collect that. The rest of it will remain open. I'm not going to impose any financial fines as it relates to all of that. I think that the sentence, of course, itself is significant and is enough. Other than that, I will recommend to the Board of Pardons you receive credit for all of the time you've served. I think statutorily you're entitled to that. But other than that, you will have 30 days from today in which you can appeal the sentence of the court. But to that end, it begins forthwith. I'll turn you back over to the department, or to the Sheriff's Office for transport down to the Department of Corrections, and you will begin to serve that sentence. Is there a request for an ongoing criminal protective order on behalf of any of the other children and his ex-wife?
Yes, Your Honor, we are asking CP, MP, as well as his ex-wife to be included in an ongoing protective order, and I will prepare that documentation and send it over to the court.
All right. Any objection to that?
No, Your Honor.
All right, Mr. Peterson, you're prohibited under the statute then, and this is a lifelong, long prohibition that you are prohibited from having any contact. Certainly it prohibits you from committing any domestic violence or any abuse of the named victims, and I will issue that order, but it is a lifetime that you have no contact with them as well. That means direct or indirect, no third party. You don't, if you have access, which I can't imagine you will, to social media, there is no commenting or...
And with that, the courtroom fell silent, but the impact of this case will last far longer than today's sentencing. The judge imposed a maximum consecutive prison terms, making it clear that the severity of the abuse demanded the harshest punishment available under the law. While the legal proceedings have come to an end, no sentence can restore the life that was lost or erase the pain endured by the surviving family. What are your thoughts on the judge's decision? Did justice go as far as it possibly could under the law?
Any issue of you addressing any of those named victims? If that needs to be changed, the Board of Pardons can certainly assess that and whether or not there's a request from the victims at any point. but otherwise you consider it a lifetime ban and a lifetime criminal protective order, an ongoing sentencing protective order. There are some other things that it includes, including a stay-away order, that you not go to any residence, that you not go to a school or work that any of the victims attend, and you not approach or go near their cars. I think those are, again, not likely ones that will come into play ever, but they are part of the standard order, and I will issue that order as well. That'll be served on you either at the jail or at the prison, but it's in effect now. Violation of that order can result in new criminal charges, and certainly it also serves as a basis to restrict any communication privileges you might have while you are confined. And I'll ask the state to prepare that, and I'll sign it.
Thank you, Your Honor.
All right, anything else from the state?
Your Honor, I have not confirmed with his attorney, but we would also probably like to add TP to that as well, to the criminal protective order as well. I can reach out.
Which one is it? Oh.
Yeah.
Any objection to that? There's a no contact order that's in place already,
Yes.
but I do think that would.
Yes, there was a no contact order.
I think there was a no contact order, especially when he was released, but is there an objection to that?
No, Your Honor.
All right. I will include Tyler as part of that then, even though he's an adult. If his counsel wants to object to that, I will amend it and remove him. But I'm not hearing any objection from your attorney, Mr. Peterson, and that means that for now, and based on this verbal order, it is in place. All right? So if you'll prepare that and send it over. Anything else from the state?
Nothing.
Anything else from you, Mr. Merrill?
I think the defendant's attorney already mentioned this, but if we could just get an order to file that financial declaration under statute 7738B204, I can prepare that order if you would like, but it's a basic financial declaration that can be found on the court's website.
The financial declaration for what?
For the restitution.
Oh, for the restitution, I see.
We'll get back to him.
Okay. And are you asking that appellate counsel be appointed for any purpose at this point?
No, Your
All
Honor.
right. You do have 30 days to appeal. If there's a change of heart and you do intend to appeal, you're certainly entitled to counsel to assist you with that if you're indigent, but I would have to assess that. So make sure that that comes to my attention before the 30 days are up. Otherwise, it's very difficult to get it back. All right? All right. Anything else from you, Mr. Whittison?
No, Your Honor, thank you.
All right. That will be all. Court will be in recess.